all right.
This court is resumed. You may be seated.
Thank you. Before we move on, I just want to clarify 2 points from our previous interaction there. One is I had misspoke when I talked about the reason the Crown was given another chance to make the decision. What I should have said was that was why the Supreme Court of Canada was emphasizing the reasons first. The reason it was sent to the Crowns to make a decision was so that they could engage in the engagement process and try to come to a resolution to I took you to the part of the Supreme Court of Canada's decision where they say that the principles should be the object of permanent negotiations between the parties. And that's why it was sent back for them to have a chance to do the right thing, was to come into reach consensus with the treaty partners. But what I meant to say was the reason why there is that emphasis on reasons and the review of the reasons is because of the relational aspect of the treaty and the fact that the Anishinaabe need to know why the Crown makes its decision that it does when they can't reach consensus, and the Crown needs to know why as well in order to conduct a meaningful review.
And how do you distinguish that from what you said earlier?
Well, before I said it was just so that the Anishinaabe could understand why the Crown decided, I sort of skipped the whole point of the negotiations. And then I guess I also want to just address the question you had about the Supreme Court of Canada giving what you refer to as strong parameters for the scope of the review.
Yes.
And I'm just not, I want to make sure I understand what your question is. If what you're saying is that they suggested it was a narrow scope of review, I don't think we agree with that.
And I didn't want to say that. I didn't use that word.
So, because as we said in our first submissions, you can review the decision to make sure it's consistent with all of the constraints listed in paragraph 197 of the decision. And that's an overarching review for liberality, justice, consistency with the Anishinaabe principles and so forth. Only one of those attracts deference. And ultimately, you have to decide whether the Crown's decision is honorable in the sense that it diligently implements the promise to share the land in a manner consistent with the treaty principles like mutual benefit. So the deference to polycentric considerations only applies to, one of the factors, and it can't justify an outcome that is substantively inconsistent with the diligent fulfillment of the substantive treaty promise. Now, I don't know if that answers your question any better, but when you said strong parameters, what were you referring to?
I was referring to the, let me see, I would say I'm referring to the language in 308.
Yeah, we have it. You can do it.
Right, and I guess our emphasis is on the first part of that paragraph, which I think one of my friends skipped the first line. If the Crown has exercised this discretion liberally, justly, and honorably, and we say honorably incorporates all of those factors we've talked about before, the Anishinaabe expectations of how the Crown would go about behaving as a treaty partner.
Is this part of your, I can't say which factor, whether the original or the reply, but where you set out the order of review, you say first, there's a threshold determination, I believe, I hope I hope I'm not getting this wrong, that there's a threshold determination of honorableness, then you look at then you review for the other factors?
No, I didn't mean to say that.
Okay.
The Crown, the judge, the court is always responsible for ensuring that the Crown's decision as a whole meets that standard of honorableness. There may be several different outcomes that would meet that standard. But it is always the court's obligation to ensure that the decision as a whole meets the standard of honorableness. And there's no deference to the Crown in that overall assessment.
Thank you.
I just wanted to go back because I had jumped forward to answer your question, and I had not finished my submissions with respect to why the Vavilov framework doesn't apply as a question of law and doesn't apply to most of the decision. And I just wanted to make a few submissions on that. We say even if you define administrative decision broadly enough to capture this decision, which we say is incorrect, even under the Vavilov test, the presumption of reasonableness is rebutted where the rule of law requires it, or including with respect to constitutional questions. And specifically, they talk about the scope of Aboriginal and treaty rights. And we say when the court is deciding whether the Crown acted in accordance with the restrictions set out in paragraph 196 and 197, then you are talking about whether it's fulfilled its treaty obligations, and that's about the scope of the treaty rights. Ontario took you to some of the Supreme Court of Canada statements that it had definitively determined the treaty right. And we say a definitive determination on one issue, which was the exercise of, or the existence of discretion, which is what they decided, is not an exhaustive determination of all the issues. No one could say there's no interpretation issues left when we don't know what revenues are included, how expenses are determined, how the principles would apply to the sharing, or even who would pay. And the Supreme Court of Canada, as I've said a couple of times, diligent implementation starts with interpretation. It would be impossible to sort out which issues are interpretation and which are implementation. The Crowns know these haven't really been resolved. They just say that now they can resolve them in their discretion, and that's not correct. So we say it's a constitutional issue because it's about the scope of treaty rights. It's about the Crown's respect for treaty rights. But I also want to say one more thing about that, and that has to do with the rule of law statement in Vavilov. Sometimes I wonder what the Anishinaabe got out of the treaty. In its factum, Ontario says, well, they got reserves and they got hunting rights and they got fishing rights. They had all of that to begin with. They had the right to extract revenue from the resources. What they got was a promise that the relations between the two nations would be conducted in accordance with principles, in accordance with the rule of law. For the Anishinaabe, that included Anishinaabe legal principles, and the Crown knew that. But they would also expect that the settler law would be applied in an even-handed way. For the Anishinaabe, the treaty has always had constitutional significance because it was the basis on which the treaty territory became a part of Canada. But now that's affirmed in Section 35. And so we say there's no doubt that it's the courts and not one of the treaty partners who has to decide if the treaty obligation has been respected. Now the Crown say, what about the duty to consult? And what about the Dore case? Well, with respect to the duty to consult, there's no reason why a breach of treaty case, this case would be the same as a duty to consult case. But even in the duty to consult cases, questions about the scope of the right, questions about whether the decision maker has adequately considered the impacts of the right, those are all reviewable on a standard of correctness. We've put into tab 3 of our compendium the decision that my friends referred to in Wabascane. And you'll see it says, it's quoting from Haida there at paragraph 46. This is tab 3 of our book. Crown decisions as to whether there are duties to consult or accommodate are reviewable on the standard of correctness. That's because they have to do with ascertaining whether there is a right at issue. The Crown's assessment of the extent of these duties are generally questions of law, reviewable on the standard of correctness because they define legal duties. That's about the impact that any proposed activity might have on them. Is it going to be a severe impact? Is it does it attract deep consultation? That's reviewable on the standard of correctness. If the Crown misconceives the seriousness of the claim or the impact of an infringement, this will be reviewable on a standard of correctness. So all of that is about the scope of the rights. Then they say, but where those depend on questions of fact and where you're talking about the process, that's going to be reviewed on reasonableness. Now, Haida is a little out of date in terms of Vavilov because you don't divide them just in terms of questions of law and so forth. But this is where you have to remember the difference between our case and a duty to consult case. Duty to consult case arises in the context of an administrative decision where the legislature has decided that the decision maker will be the one who decides what the facts are. And the minister can do, and the legislature can do that. The legislature can pass a statute that gives decision-making power in first instance to a tribunal or to a minister, and they're expected to decide the facts, and respect for legislative intent means we are respectful of that. The Crown can't decide on its own motion that its minister, its own official, will be the one to decide the facts arising from this treaty. That's why this is a different context. With respect to process, the Crown's made some submissions about Ontario, I believe, made some submissions about how what is adequate for the duty to consult is relevant here with respect to the duty of engagement. And this applies both to why the duty to consult is different in the purposes of the standard of review and the content of what's required. This is completely different than the duty to consult. The duty to consult arises when the Crown is administering its own policy, law, legislative framework. This is a process, a promise, a constitutional promise to engage in a particular kind of relationship with the Anishinaabe governed by certain principles. We all went through a lot in a trial to discover what those principles were, and they've been recognized all the way up to the Supreme Court of Canada. And the Crown sees, well, we don't have to worry about all of that because it's basically just the same as the process for the duty to consult. That can't be right. And then the Crown say, well, what about Dore? And I understand there is a sort of superficial similarity between discretionary decisions of a tribunal that implicate charter values and the exercise of the minister's discretion under the treaty. But the context is entirely different. And so the rationale behind Dore is not applied here, cannot be applied here. Tab 4 of our compendium is the Trinity Western University case. And Dore deals with a specific problem, which is whether when an administrative decision implicates charter rights, you have to go through a whole Section 1 analysis under Oakes, or which doesn't fit well with the administrative decision-making process. Or whether what you're doing is you're reviewing their proportionate balancing of the charter rights against the statutory scheme. So you'll see, starting paragraph 79, the second page over, page 14 in the upper right hand. Under the Dory framework, the administrative decision will be reasonable if it reflects a proportionate balancing of the charter protection with the statutory mandate. Dory's approach recognizes an administrative decision maker exercising a discretionary power under his or her own statute typically brings expertise to the balancing of the charter protection. The decision maker is in the best position to weigh the charter protections with his or her statutory mandate in light of the specific facts of the case. So it's about weighing, instead of doing, when there's an interference with the charter, right, you can go to section 1, or you can see whether this was done as a proportionate balancing, having regard to the statutory objectives. We don't have any statutory objectives here. We're not talking, I don't think, about justifying an infringement of a right. Dory is of no assistance. So we say that those were all our reasons for saying that you don't just import holus bolus, the administrative law framework, into this context. Instead, you have to look at the specific context here and develop a sui generis standard. Now, Canada seems to accept that the administrative law standard doesn't apply, but it says that reasonableness is the same, or honorableness is the same as reasonableness. And we say that is not correct. We agree with Canada that any honorable decision has to be reasonable, but we don't agree that any decision that is reasonable, that might meet the test set out in Vavilov, is necessarily honorable. And again, we say this is just an attempt to sort of take away the Anishinaabe perspective from the whole analysis. Treating honorableness and reasonableness as interchangeable sort of hollows out what honorableness means, takes away its unique context and fills it with an entirely Eurocentric framework of analysis, and therefore erases the Anishinaabe perspective.
Can I just check to see what's going on with the reporting? Is it just my screen, or is there something?
No.
Tell me, we're blocked? Okay. I'm going to ask you for that. The reason I was looking at the reporter's screen was I'm going to ask you for that last proposition again. You started with any honorable decision must be reasonable, but you do not agree that any reasonable decision is necessarily honorable. And then I missed you.
So we say that not everything that meets the test of reasonableness under Vavilov would necessarily be honorable, because the honor of the crown and the duty of diligent implementation involves incorporating the Anishinaabe perspective and Anishinaabe treaty principles into the analysis of the crown's behavior. So to say that they're the same thing sort of hollows out what honorableness means. It takes away its unique content and just means it's completely
You cannot say that they're the same thing as reasonableness?
Honorableness and reasonableness can't be the same thing. They may share certain traits, but it's not the same standard, which is, I think, what Canada said. It's a separate standard as honorableness, but in function, it's the same as reasonableness. We say there's no reason to believe that that is so.
I'm just going to ask the report. Do you need time? But let's take a minute, please.
All right.
Worry about mine, just worry about hers.
This court is stood down until recalled.
Don't worry about
We've
mine,
got one
just see-
working
yeah,
here
just
and
see if
then
hers is-
one is not.
Court is resumed, please be seated.
So I just have two final things to do. One is when I went back over the transcript, my first submissions, I saw there were many times when I used the word reasonable when I meant honorable. So I think that just, as I said, is a effective, usually doing administrative law cases where it's honorable. So I'm just going to give you those sites, page 773, line 22, 778, line 15.
Oh, I'm going to ask you to stay slow if you don't mind. I've got the first 773 line 2.
To 22.
Okay,
These are the current citations.
right.
778, line 15.
Okay,
7792 and 78619. And I think that last one is the one that Ontario has talked about, where I talk about reasonable ways of calculating the revenues and expenses. And again, if they're all reasonable and they're all honorable, then you don't have to second guess the Crown's choice, as long as they're all honorable.
and that was on, you think that's on the page
786.
786 one?
I believe so, yes. So I just want to leave you with this. If all the Anishinaabe have under this treaty is a right to a chain of reasoning from the Crown and a review for consistency with the facts and law on a deferential approach, where the treaty principles that they understood would be followed in the exercise of the Crown's discretion are nothing more than guidelines that the Crown can consider and reject where it sees fit. If liberality and justice require not the generosity and love referred to by Elder Corbier and other experts on the Anishinaabe perspective, but just taking into account polycentric considerations, well, then the sacred promise to share the wealth in a manner consistent with the Anishinabe's understanding isn't attracting any real protection at all. And we say that cannot be what the Supreme Court of Canada directed this court to do. Subject to any questions, those are our submissions.
Thank you very much. Okay.
Good afternoon, Your Honor.
Afternoon.
I'll be making brief reply submissions on behalf of the Teme-Augama, Anishnabai, and Temagami First Nation.
Thank you. And could you identify yourself for the record? please?
Katherine Brack. So in our earlier submissions, we outlined the need for transparency and clarity as to how the legal principles should be interpreted and applied in the sui generis review hearing. After listening to the submissions of my friends from Canada and Ontario, I'm afraid I'm left with more questions than answers. Now that we've had a chance to hear from the Crowns, I want to ask again, do we have more clarity on the legal principles and confidence that both the January 27th decisions and the engagement process were honorable? I submit that after hearing from the Crowns, the proper approach for addressing the central questions raised in this review hearing have not in fact been clarified. If the Crowns can't agree on an honorable approach, how can the Treaty First Nations have confidence that the Crown is exercising its discretion honorably, liberally, and justly? How can this court?
Do you say because they use different reasoning that they don't agree on the reasoning? Is that the same thing?
Yes, that's part of our submissions.
Okay, thank you.
So if this court finds that the amount is dishonorable, we urge this court to step in and make that determination. If this question is sent back to the Crowns, Given the outcome that we currently have on our hands with the decision letters and the state of things, which I will get into more detail later in my submissions, I would submit that the likely result would just be more confusion, more questions, more dishonorable conduct, and we might find ourselves back before this court again. So briefly, I want to touch on two things. First, the standard of review. With regard to the standard of review, little deference is owed to the Crown, as the primary question is whether the amount and process were honorable. And then my second point, which I'll go into, is in relation to the remedy. If the court determines that the amount was dishonorable, the court in this instance can and should we submit, step in and substitute its own decision on proper compensation. So to address the first topic of standard of review, as we submitted previously, minimal deference is afforded due to the constitutional guardrails here. I'm not going to repeat that argument. I also agree with my
You adopt the arguments of whom?
I'm not going to repeat the argument that we made earlier in the first week. Yeah. But I do agree with my learned friend, Ms. Boise-Parker, and submit that this court should not be constrained nor consumed by questions of administrative law, since this is not a judicial review. And fundamentally, it is about what is just, liberal, and an honorable amount. So further to your earlier question, Justice Hennessy, about what a sui generis treaty relationship and a sui generis review process requires, I would like to build off with what Ms. Boise-Parker said and say that the focus of this review should not be on, the focus of this review should be on the remedy and the outcome. So the question is how to rectify the breach of this treaty. What is just? That's what reconciliation requires. So we are bound by the constitutional constraints, including the honor of the Crown, but we are not bound to a strict approach of administrative law principles.
Okay, so this is a tough question, and bad luck for you that you get it first. So if you say to the court, as you do, that the amount and the process were not honorable, do not meet the test of honorableness, and that the remedy is for the court to step in, I think I can understand how you and your related parties would like the court to step in on the question of amount.
Mm-hmm.
But what do you say the court should do with respect to process if you say it has not been an honorable process?
Yeah, we would submit that we require further direction on what an honorable process would look like and what went wrong in that process. And that can be compensated as part of this hearing and this review process.
But if you say you want direction, then you are necessarily saying that this review itself should be setting the direction for future annuity future annuity engagement processes. Is that what you're saying?
Yes, especially from the perspective of Temagami, it's critical that we have guidance on how the relationship works, how the engagement process works, and what is honorable in terms of that negotiation and engagement process. So in terms of deference, we would submit that it is further constrained because of potential issues with the Crown's reasons for determining the amount. If the court finds such issues, such as if the reasons appear to be reverse engineered or use two different methodologies, or that there are substantive issues with the negotiation and engagement process and that it was approached without an open mind or view to compromise. So I'll touch on these in more detail later. And then discretion also needs to be constrained because of the legal and policy considerations, including the fact that the Crown should not have another chance to rectify the breach if the amount is found to be dishonorable. So these legal considerations are the guardrails of the Constitution and the requirements set out regarding the treaty and rest rule. I won't repeat these. Other considerations that push this review towards minimal deference afforded to the Crown include the need to avoid further delay and confusion, the need for finality on this matter, and to avoid a series of attempts by the Crown to engage and get things right.
Well, when you start out this proposition by saying minimal deference afforded to the Crown include the need to avoid further delay. That when you say the need to avoid further delay and confusion, that is in support of your argument that if this court finds that neither the amount nor the process are liberal, honorable, and just, that the court should make its own determinations. But how does that fit with deference? That's just on remedy.
Mm-hmm. I would submit that every issue found, so every moment of dishonorable conduct further should constrain that window of deference. I would also submit that the need for legal clarity and the importance of having consistency and clarity on these questions of treaty interpretation and application with regard to the precedential value of this proceeding are critical. The normative reach of this decision, the importance of having consistency in the interpretation and application of this treaty and its animating principles, these are all going to apply potentially to my client going forward. Finally, on my last point with regard to standard of review, we are concerned to hear that Canada appears to be conflating or equating honorableness and reasonableness. Now, these concerns were just similarly raised by my learned friends, so I won't repeat them. But I will state that in this review, honor of the Crown is at issue, and the Supreme Court used the term honorableness and honor of the Crown for a reason. So our concerns arise that Canada is trying to shoehorn in a reasonableness standard to fit better with the argument for a deferential or reasonableness standard of review, whereas the Supreme Court didn't say the standard was reasonableness, it said honorableness. My second overarching point is that the court can and should substitute its own decision. It is within the purview of this court to determine if the amount was honorable, and if it was dishonorable, it should step in and substitute its decision. As Canada conceded in its submissions, the Supreme Court said the court could either send the decision back or make its own determination. The Supreme Court didn't show preference for one or the other, but that was before the engagement process took place. Now that the court has the benefit of examining the engagement process and the resulting exercises of discretion, including the reasons for the exercise of that discretion, if the court is not satisfied that the process was honorable, we would submit that it is inappropriate to send it back to the Crowns again. This is the proper remedy, not only to rectify the breach of the treaty and the breach of diligent implementation, but to also rectify the breach of the honor of the Crown as a result of the engagement process, should the court find that it was dishonorable. So this case is about fashioning a liberal, just, and honorable remedy. If the Crown didn't do that, that's where the court must step in. This is why the court in Restual ordered a deadline of 6 months and also provided for the reviewing court to be able to step in and substitute its decision. Support for this is found at paragraph 291 in Restual. Court says, for example, a failure by the Crown to pay an honorable amount in all circumstances should not limit a court to quashing the amount set aside by the Crown and remanding the issue to the Crown for redetermination. In such a case, the court may need to make a determination that the Crown refuses to make or that it makes dishonorably. The Crown cannot be allowed to continue to undermine the very object and purpose of the treaty promise. So these things, when taken against the backdrop of deficient reasons and a dishonorable amount, should the court find that, provides a clear path forward for the court to step in. Now that we have the benefit of reviewing the decision letters, reading the factums, hearing from my friends from Canada and Ontario, the question that I am left with, and the question and issues we submit the court should consider when looking at this are, what does the honor of the Crown mean in terms of the Crown's discretionary decision for past compensation? So what does the honor of the Crown mean in terms of this engagement process? What does it mean in terms of the reasons and rationale for coming up with the total amount? The court in Restall directs that at paragraph 308, the court should focus on the justification of the Crown's determination, having regard to the honor of the Crown. The honor of the Crown we submit means the following. It means a decision that is not constrained by the legal and constitutional, a decision, that is constrained by the legal and constitutional principles. It is not unfettered. The rule of law must apply. Honor of the Crown means that the outcome must not be predetermined, that the Crown must come to the table with an open mind. The honor of the Crown means that the engagement process must be a true negotiation between the treaty partners and the Crown. And the Crown should have to be not just the First Nations, but the Crown too must be ready and willing to reach a meaningful and substantive compromise. Honor of the Crown means not just be open to listening, open to hearing concerns, as Canada has stated, or it means not just to take information under advisement, which often happens in the duty to consult context. It means something more than making small adjustments to a position. Honor of the Crown requires actually negotiating, learning, compromising, and revising one's position. The term negotiation itself implies moving toward consent and agreement. The Supreme Court used the word negotiation. It did not use the word consultation. Honor of the Crown requires having clear, principled, and detailed reasons for justifying the exercise of discretion. This includes properly fleshing out and justifying polycentric considerations if they are to account for an amount that is less than, say, the full net economic value that the Crown received from the territories. The honor of the Crown also means not reverse engineering reasons. It means having consistent reasons. This goes to your question earlier, Justice Hennessy. The honor of the Crown means consistent reasons between each Crown, not reasons where the numbers match, but the methodologies are drastically divergent. So we submit that the court must ask itself if the Crown did all of these things when considering the issue before it and when determining what the appropriate remedy is. We raise these concerns that the standard of honorableness has not been met in this case because in the Crown submissions last week, they did not provide any further clarity on how their reasons met these principles that I've just laid out to demonstrate that the exercise of discretion and the reasons for justifying it and the process were all honorable. Instead, Ontario has resorted to what could be characterized as sharp dealing, such as splitting hairs over an overly technical attempt at parsing out what liberal means and when it applies. Ontario submitted that the Supreme Court said that the Crown has to be liberal and just in determining the amount, not that the amount itself must be liberal and just. We would submit that the honor of the Crown requires to avoid such sharp dealing. This is confirmed at Restoral at paragraph 221, where it cited Badger. Again, we heard last week, each Crown has two different reasons for exercising the discretion and determining the amount. We are concerned that there are two separate, completely different rationales, and we ask, how can this be honorable? Two different sets of reasons using widely different rationales and explanations leaves us with confusion over what the honorable approach to take is, and confusion about how to engage with the Crown. Regarding Crown allocation, I submit that it is not honorable for the Crowns to continue to be disputing this issue throughout the engagement process. And that if this court sends the matter back to the Crown for further consideration, this dispute over allocation may very well continue on, with the First Nations again having to sit as spectators, subject to and prejudiced by this dispute. Ontario says Restoral directs its approach. Yet it decides unilaterally to ignore.
Excuse me.
Yep.
You haven't thought of this possibility. Should there be a decision on Crown allocation and a decision, these two together, and a decision to send the matter back? Then it wouldn't be a dispute necessarily between them.
No,
It would be an appeal.
it's true. And I mean, it's out of our hands at that point.
No, I'm talking about what it means for the parties, the plaintiffs, related parties, if there's an appeal. Would an engagement process take place during an appeal?
That is an excellent question and something that my client is struggling with as well. How do we proceed with our relationship with the Crown when this hearing is ongoing? There's open questions that need to be decided. When is the appropriate time and place to continue that engagement when we need finality on a lot of these legal issues? So I don't have an answer for you.
But do you say that's the case, that Temagami is somehow limited in how they engage with the Crown, given this litigation or the stages of this litigation or where we are in this litigation?
Yeah, it is. I'm not sure limited is necessarily the correct approach, but certainly it's causing concerns that we can't fully figure out what position to take because there is so much uncertainty. Not only do we have two different justifications and methodologies that the Crown presented for coming up with a total number, granted the factual circumstances may be different, but we also don't have certainty on a lot of the legal principles. So we are grappling with how best to proceed. How do we not prejudice our client, but also work towards a meaningful result and further the treaty relationship and define and renew what that means.
Thank you.
Ontario last week said Restoral directed its approach, yet it decided essentially unilaterally to ignore the Anishnabai principles of respect, responsibility, reciprocity, and renewal by framing them instead as considerations rather than constraints, or trying to parse them out as only applying in the judicial review context rather than animating treaty principles. We are concerned by this approach. Surely restoring the honor of the Crown and the court's determination of that means an examination of what the Anishinaabe treaty partners' perspective on whether the honor of the Crown has been restored, especially in the case of a treaty. The nation-to-nation relationship is at stake here. The need for the parties to work together and restore and repair that relationship. Surely honor of the Crown and whether the Crown acted honorably must be assessed in accordance with these Anishinaabe principles. With regard to Ontario, my friend submitted that the default administrative law remedy is to remit the matter back to the decision maker. While we don't accept that this is a judicial review, nor that a reasonableness standard applies, Ontario, when discussing reasonableness, also failed to take the court to the exceptions noted by the Supreme Court in Vavilov, where the court may consider substituting its own decision in the context of a reasonableness review. We find this at paragraph 142 of Vavilov. Quote, this process, not quote, a judicial review, I will summarize, and then quote, cannot give rise to an endless merry-go-round of judicial reviews and subsequent reconsiderations. We are concerned about this particular point here. The Supreme Court continued on at paragraph 142 that, quote, elements like concern for delay, fairness to the parties, urgency of providing a resolution to the dispute, the nature of the particular regulatory regime, whether the administrative decision maker had a genuine opportunity to weigh in on the issues and questions, costs to the parties, and the efficient use of public resources may all influence the exercise of a court's discretion to remit the matter, just as they may influence the exercise of discretion to quash a decision that is flawed. So all of these delay, fairness, cost, efficient use of public resources to the parties, these are all animating principles for us. So in conclusion, if Temagami is going to mend its relationship with the Crown, it needs clarity on what approach is the appropriate one under the treaty to compensate for past breaches under the augmentation clause. What we need is a review that looks to honorableness as the standard for an appropriate and just review. If the amount is dishonorable, then what is the remedy? Issues with both the Crown's reasons for exercising discretion and the engagement process itself requires the court to step in rather than send it back. So subject to any questions, that concludes my submissions.
Thank you very much.
Thank you.
Good afternoon, Justice Hennessy. I'm just going to start ahead and we'll take the afternoon break at some point coming up soon.
If you could just introduce yourself.
Yes, that was my next order of business. It's Spencer Bass for the Contingent Interest First Nations. And just in terms of reply for a roadmap, I'm going to be making brief submissions on the standard of review, the approach to compensation and past augmentations, and the bring forward rate. And then Mr. Gover, likely tomorrow morning, will speak about the RHT settlement and the Crown's claim of independence from each other, 2020 to 2024 revenues, charter damages, and then finally brief submissions on the share for the Contingent Interest First Nations. And just before I launch into my submissions, I do have a matter of housekeeping, which is Your Honor asked me 2 weeks ago to set out the particular numbers for the Contingent Interest First Nation shares. I promised that it was just a matter of math, simple math, and it has ended up being so. I've reached agreement with all of my friends. We've set it out in a chart for the court. I've already sent it to my friends. These numbers are not in dispute, but I've set them out for Your Honor.
Thank you very much. And you've given a copy to the record.
I am doing so right now.
Very nice. Thank you. And you intend it to be an exhibit or for court's assistance, I suppose, a lettered exhibit?
It is for the court's assistance. I was going to suggest a lettered exhibit just for identification purposes.
Great. If I may,
Yes, sir.
this was done this morning and I don't object to the material going to Your Honor. I just want to note that I didn't have a full opportunity to review it before it was finalized, or at least it was finalized in the morning's hearing, and it's given subject to Ontario's position on Crown allocation. I don't object to it going to you, it's fine, but just when you consider it. Ontario's position on Crown allocation. That's all. Thank you.
Oh, you're agree. So I don't see anything on the chart with respect to allocation as between crowns.
But it's not the chart, sorry, there's some wording in the document that I
Oh, okay.
done differently if we'd had more time, but I don't want to hold things up, and it's fine to go ahead. And so I just wanted to note that for the court.
Thank you.
My apology, I didn't mean to misrepresent my friend's position at all, and perhaps if we have to file a revised version tomorrow after
Or file it
discussion.
tomorrow. I'll hold it. And if,
There's no need to, no, you're on. There's no need for a revised version.
Okay.
oh, okay.
What I've said on the record is fine.
All right. So G, what are we at? H. Exhibit H, and it will be called distribution chart for contingent interest First Nations. Thank you very much.
So just at the outset, I would note that the review here concerns both the process and the outcome of the Crown's exercise of discretion. Some of the points that myself and my colleague, Mr. Gover, will speak to relate to the process, some relate to the outcome. Fundamentally, though, our position is that the process was not a genuine search for an honorable result. It was a reverse engineered exercise to justify a predetermined cap to the amount of compensation. And in the end, the process was deeply flawed and the outcome cannot stand. So my first set of submissions relate to the standard of review. And the first thing that I want to speak about is Ontario's approach in this case, which we say hollows out the treaty right. Because when the various aspects of Ontario's submissions from last week are put together, the result with respect is quite insidious and deeply concerning to our clients. And I want to take you through how we interpret how Ontario's submissions fit together. Because first, Ontario told you that the review of the Crown's exercise of discretion is merely a judicial review according to administrative law principles. And therefore, the court must apply the reasonableness standard to the minister's decision. But never fear, Ontario tells this court and its treaty partner, because according to Vavilov, reasonableness is a robust standard. It doesn't mean unfettered discretion, and it doesn't mean the minister can do whatever he wants. Because, Ontario says, the discretion must be exercised in accordance with the legal and factual constraints that bear upon the decision. And that this court can still review the decision to ensure that it is consistent with those constraints. That's the effect of the submissions on standard of review that you heard from Mr. Rankin on behalf of Ontario last week. But then you must consider those submissions in light of what else my friends for Ontario told you. And specifically, I'm referring to the submissions that you heard from Mr. Ogden. Because Ontario's next move, after they've sought to establish the reasonableness standard, is to then remove the legal and factual constraints from the minister's decision. And they accomplish this through an extreme parsing of the language of the Supreme Court decision to actually say, well, there aren't that many constraints on the minister's decision. So, for example, firstly, the Anishnabai principles of respect, responsibility, reciprocity, and renewal. Well, for Ontario, these are not robust constraints on the decision because, as Ms. Boise-Parker referred to this morning, and I'm not going to repeat her submissions, but Ontario says the compensation doesn't need to be consistent with those principles. They're only guidelines. And it's only that the relationship is based on these principles. So that's one constraint, removed or watered down. Then Ontario says, well, the Supreme Court only told them to consider the severity of the breach. And Ontario sought to differentiate the word severity from the word seriousness, as the latter term was used in the Ward decision from the Supreme Court. And they said that because the Supreme Court used the term severity, not seriousness, well, that means the minister doesn't have to consider the effect of the breach on the Anishinaabe people. They said that only relates to seriousness of the breach, and the Supreme Court only told us to consider severity. And we say, of course, there's little meaningful difference between considering the severity of a breach and considering the seriousness of a breach, and both require the wrongdoer to grapple with the impact of the breach on the wronged party. But this is another constraint that Ontario seeks to remove. And further, in Ontario submissions last week, my friend told you that according to the Supreme Court decision, the Crown must exercise its discretion liberally and justly, but that nowhere does the Supreme Court say the amount has to be liberal. And we'd adopt the language that Your Honor used in a question to my friend, that this is splitting hairs. What Ontario is saying is that the Crown must be liberal and honorable in determining amount of past compensation, but the amount itself doesn't need to be liberal and just. And my friend for Ontario walked Your Honor through several paragraphs of the Supreme Court decision in an attempt to illustrate this. But one paragraph that he did not take you to is paragraph 290. And I would direct your attention to that paragraph now. And it's the start of that paragraph. And it's Ms. Angelova has shared it on the screen as well. Go ahead. So there the Supreme Court writes, the Crown must exercise this discretion liberally and justly, consistently with the honor of the Crown and the language of the treaty itself, but it retains the authority and, in the present circumstances, has the obligation to set a figure that it considers will meet those requirements. And so here the Supreme Court is clearly instructing the Crown to set a figure that will meet the requirements of liberality, justness, and the principles underlying the treaty itself. So we submit that Ontario is wrong here in seeking to remove yet another constraint on the minister's decision. And once all of these constraints are taken away, what the Anishinaabe are left with is an impoverished view of the honor of the Crown and the treaty right. And that's why we say the right has been hollowed out. Right? So this is Ontario's two-step process. First, the level of deference, and then secondly, they remove the legal and factual constraints that bear upon that decision. And what is left is something dangerously approaching unfettered discretion for the minister to select almost unilaterally what he believes is right for the First Nations. That is not the relationship that the Anishinaabe people agreed to in 1850. And it leaves them with the same empty shell that they've had for over a century and a half. So you've heard many submissions from, I think initially from our side, then from Canada, then from Ontario, and then from our side again on the standard of review. So I'll seek not to spend too much more time on this area, but I do want to reiterate our position that the standard of review doesn't determine the result in this case. And in our original submissions, when I was up 2 weeks ago, we expressed the view that there are questions in the Crown's exercise of discretion that go to the Section 35 treaty right and the nature of the obligations under the honor of the Crown, and that these are constitutional questions that must be answered correctly. And I had said that if the Crown is incorrect on these interpretive questions, then the resulting exercise of discretion cannot be reasonable. But whether you consider them as extricable constitutional questions or questions of interpretation or legal constraints that bear upon the decision under a Vavilov style of reasonableness review as true constraints that exercise on that operate on the decision, the result is the same. Which is that if the Crown gets them wrong, the decision cannot stand. It cannot be honorable. It cannot be reasonable. So I want to take you to a concrete example from this case of how we say that this operates. And that is, does the Crown need to account for the lost opportunity of the Anishnabai through the bring forward right? If this court concludes that, according to the treaty and the honor of the Crown, they must do so, then the fact that the Crown did not do so renders the decision dishonorable and unjust.
When the court said that this process shall not begin as an open-ended question of, I'm not sure what they said, calculation of damages or something. Do you say that they are saying anything about breaking down the factors that go into the decision, i.e. bring forward rate or approach to expenses for NCRRs or percentage share? Do you say that the Supreme Court is telling this court on review to go to each of those questions and make determinations, and looking therefore at how the Crown has made those determinations?
So, of course, what the Supreme Court did say is that stage 3 would not begin as a damages trial. And so what the Supreme Court was saying is that the next step after the decision from the Supreme Court was not for us to come back to you and say, okay, that decision that you've been working on the stage 3 trial, you can release that decision now and determine what the appropriate amount is. But that the next step was the engagement process and the exercise of Crown discretion. And that the first thing that this court would have to do is review that exercise of discretion. Of course, if an agreement was not met and the First Nations returned to court, but we're past that step. So the first step would be a review of the Crown's exercise of discretion. And there is deference applied to certain questions, we say, to the Crown's exercise of polycentric decision-making, the balancing. And the Crown would take a position. They'd have to take a position on things like the NCRRs, or the revenues from the territory, the bring forward rate, the level of sharing, the form, level, and aim of sharing. And the court would then be entitled to review that for honorableness, for consistency with the treaty and the honor of the Crown. And of course, if the decision was dishonorable, They then said, well, this court has different remedies available to them, one of which is to set the appropriate amount, set the honorable amount. And of course, if the court undertakes that process, well, then this court is going to have to delve into those questions.
But that's at the end of the work that you say this court has to do. But how do you get there? How does this court get to looking at the amount if it doesn't engage in an assessment of each of those questions?
Well, I think the first step there on the review of the honorableness of the decision does require this court to assess how the positions that the Crown has taken on those matters.
Right.
So you've heard from the Crown, predominantly from Ontario, well, the government bond rate is appropriate because we're measuring the benefits to the Crown, and that's all that we have to measure using the bring forward rate. And I'll have more to say on that in a little bit, but the court is entitled to review that and look at that. Is that honorable? Is that consistent with the honor of the Crown in this case? Is that consistent with what the treaty requires? And of course, if it is not, and this court decides that the appropriate remedy is to set the amount itself, which we urge you to do so, then the court will have to delve into the issue of what is the appropriate bring forward rate or a range of appropriate bring forward rates. And so just to return to the point that I was on, whether that question of does the Crown need to incorporate lost opportunity in the bring forward rate? Whether you say, well, this is a constitutional question that goes to the obligations flowing from the honor of the Crown and must be answered correctly, or it is a legal constraint. The honor of the Crown is a legal constraint that bears upon the reasonableness of the decision. The fact that the Crown has refused to account for the lost opportunity renders the decision unreasonable, dishonorable. It cannot stand. So perhaps I have a brief point that I could probably wrap up before we that Ontario relied on. And it was in response to our submissions on the Crown prerogative and the fact that the authority in this case arises from the treaty itself. Ontario pointed to judicial review cases and duty to consult cases in relation to taking up clauses under the numbered treaties. And specifically, they referred to the recent Wabauskang case from the divisional court. I can spell that for Madam Reporter, Wabauskang. And just briefly, it is important to recognize how that case is distinguishable. So Wabauskang was before the divisional court because it originated from an application for judicial review, because the First Nation or the First Nations, there were multiple of them in that case, they were challenging the exercise of a statutory power. So specifically in that case, the Crown, through directors working for the Ministry of Natural Resources, decided to first amend a Crown land use policy atlas and then dispose of land under the Public Lands Act. And so Ms. Angelova now has put up paragraphs 11 through 13 of the Wabauskang decision. I don't intend to read them out to your honor, but in these paragraphs, the court is outlining in the background what is the decision that is being reviewed here. And you can see that it stems from a statutory source. What was being challenged was the reasonableness of the exercise of statutory power that had been delegated to the ministry and then subdelegated to directors within that ministry. And that's very different than the power that the Crown has exercised here. Right? The only reason that the Crown has the power to exercise its discretion to determine an amount of annuities is because the parties decided to bestow that power on the Crown within certain limits through the treaty. And just finally, on the duty to consult, in her submissions on behalf of Ontario, Ms. Keenan argued that the duty to consult was retrospective because the court is reviewing a decision that has already been made or reviewing consultation that has already occurred. And I just wanted to clarify our submissions when we said that the duty to consult cases were distinguishable because that duty is prospective. What we meant by prospective is that the duty to consult applies prior to any breach of a treaty or Aboriginal right. It functions to avoid such breaches. And so specifically, if consultation was sufficient, there will often be no breach of a treaty right. We say here, the exercise is fundamentally different because the breach has already been established and in fact admitted by the Crown. And we're discussing how to remedy that breach and restore the Crown's honor, which is different than the prospective duty to consult. And perhaps that's a good place to take the afternoon break.
Thank you. How are you and your friends doing for time?
I think we're doing all right, probably a bit behind, especially with the tech difficulties that we had. I'm going to consult with my friends over the afternoon break and we'll let you know.
All right, thank you. Take 15.
Or sit down for 15 minutes. This court is resumed. Please be seated.
So just in terms of logistics, before I return to my reply submissions, I've had a discussion with my friends. We're still aiming to be finished by the end of the day tomorrow with Mr. Schachter's submissions following those of the Contingent Interest First Nations. But there is a chance that we may need to go over onto the Friday, which of course we do have reserved and set aside. So I think our request now is not to do an early start tomorrow, do regular court hours. Of course, if we come towards the end of the day tomorrow and it looks like we only need a half an hour left or something like that, subject to your Honor's thoughts at that time, we may want to stay a bit late if we can wrap it up tomorrow, but I think our request is not to start early tomorrow.
Okay, thank you.
Of course, subject to anything that your Honor says are your preferences. So the next area that I wanted to cover is to return to something that we heard from Ontario last week about past augmentation decisions being unknowable. And in his submissions last week, Mr. Ogden, on behalf of Ontario, spent a great deal of time explaining to you that it's impossible now to go back in time and recreate the augmentation decisions that the Crown, acting honorably, would have actually made from time to time. And what my friend did not really touch on in these submissions is why this is unknowable now in 2025. And of course, the why flows from the Crown's longstanding and egregious breach of the treaty. For 175 years, the Crown never even turned its mind to augmentations above $4 per person. For 175 years, the Crown did not retain records for its revenues and expenses, specifically from the treaty territory. And that's the reason why we can't know precisely how much an honorable Crown would have augmented the annuities in 1925 or 1950 or 1975, for example.
Well, isn't another reason, I believe, raised by the Supreme Court and also by Ontario, is that there's an exercise of discretion involved. And we can't know how the Crown might have exercised their discretion in all of those years.
But had the Crown been acting honorably and diligently from the start, we could. Had the Crown been acting diligently and honorably in 1925, for example, they would have exercised their discretion honorably and in accordance with the treaty promise. The reason why it's so difficult to go back and recreate those discretionary augmentations is because the Crown neglected to do so. Or even if the Crown maybe wasn't acting to the full standard of diligent implementation, but in 1925 turned their minds to an annuity augmentation and said, well, we're not going to do one this year, and provided their treaty partner with a reason. And maybe that reason was insufficient, dishonorable at the time, but if they had at least provided those reasons, we could go back and look at those reasons and assess them.
So isn't that your better argument? That you don't have you don't have 170 years of reasons.
We don't have 175 years of reasons. We don't have 175 years of data even. And the fundamental point here, of course, is that's through no fault of the Anishnabai. And it is difficult, but luckily, the Supreme Court has given us guidance on how to approach such problems when the goal, the aim, is reconciliatory justice. And of course, that comes from the recent Takuhikan decision, and specifically paragraph 225. And in that case, the Supreme Court said that it was not possible to determine the position that the respondent, the First Nation in that case, would have been in today, but for the Crown's dishonorable conduct. But because it was the Crown's dishonorable conduct that made it impossible, the First Nation could not be penalized. And I've paraphrased paragraph 225, and Ms. Angelova has put it up on the screen. And so in Takuhikan,
25 or 75?
225.
Thank you.
And so in accordance with reconciliatory justice in Takuhikan, the court simply ordered the Crown to cover the full amounts of the deficits that the First Nation had taken on. And so
We don't, in Tahukikan, we don't, the Supreme Court doesn't wrestle with or address a matter of discretion.
not in as many words, but of course the issue in that case was that the Crown, being Quebec and Canada, did not engage honorably in good faith negotiations with the First Nation regarding the funding of its police force.
A rather simple decision, policing cost X.
Well,
The full cost of it.
I mean, not necessarily, because what the Supreme Court, what Justice Kazir is getting to in this paragraph is that we don't know if the Crown acting honorably and reasonably would have necessarily agreed to cover 100% of the costs. The parties may have met, negotiated, and even with honorable negotiation, may have come to some other agreement, some sort of cost-sharing agreement, for example. Or no agreement at all. The court, as Mr. Shackers reminded me, of course, the court does say, you know, reconciliation doesn't necessarily demand an agreement in every instance. And the difficulty is because the Crown did not act honorably, we don't know what the agreement may have been or could have been. But that's not the fault of the First Nation. So rather than penalize them and go back and send them for a damages assessment, we're going to award them the full amount of the deficits.
Thank you.
And so we agree and accept that it is at the very least incredibly difficult, if not impossible, to go back in time and recreate the annuity augmentations that an honorable Crown would have provided. But we say, in accordance with reconciliatory justice and Takuhikin, that doesn't mean that we just disregard the losses to the First Nations. That is precisely why we say, and you've heard it from our side, you've heard it from Canada as well, that the exercise before the court is an assessment. It must be a flexible approach to achieve reconciliatory justice that takes into account reasonable compromises. It is not a precise mathematical calculation of losses, and that's not what we're asking for. And we submit that we have proposed an honorable way to conduct that assessment, including through reasonable compromises and a bring forward rate that seeks to account for the losses actually suffered. And this leads me to a related point, which is the appropriateness of, in the words of my friend for Ontario, a proxy share. And Mr. Ogden, on behalf of Ontario, focused on why it's improper or inappropriate to use a proxy share, he called it. And as I understood his submissions, that's essentially taking a single share and applying it to the entire retrospective period. And at least one of the rationales, or the main rationale provided, was that had the Crown been acting diligently and honorably, it would have honorably applied different levels of sharing at different time throughout the past 175 years. And that's true because the amount of benefits, the needs of the Anishnabai, the wider needs of others, those would have fluctuated from year to year. But we submit that what Ontario glosses over is that any amount of past compensation that is set in 2025 can be expressed as a percentage of revenues, whether as percentage of NCRRs, percentage of rents, and even Ontario's amount can be expressed as a percentage of wealth. It is, whether you want to refer to it as 100% of their calculation of NCRRs plus 25% or 125%, 133% of their calculation of NCRRs. And of course, even if it were theoretically possible to go back and mathematically recreate every annuity augmentation that should have occurred, we could look back at it in 2025 and with the help of someone who's better at math than me, determine what the actual percentage share of overall revenues is. And for that reason, we say, given the nature and severity of the longstanding breach, which again prevents us from going back and doing that mathematical calculation, there is nothing improper about applying a share to the entire period that attempts to assess, and again, assess, not calculate, an honorable amount of past compensation. And indeed, that is even what Canada has done in its assessment. And I don't think I heard from my friends for Ontario that they were arguing that Canada acted dishonorably by using in the words of Ontario's counsel, a proxy share to apply to the period. And so the share that is applied can, and we say should, make allowances for the needs of the Anishinaabe alongside the wider needs of other populations. And it can accommodate the Crown's polycentric decision-making where those polycentric considerations are explained and justified with the requisite amount of specificity. And I'm not going to repeat Mr. Gover's submissions from 2 weeks ago on that point. And so we say that the plaintiffs have nonetheless compromised on a 50% sharing as a reasonable place to assess compensation for the past, acknowledging the wider needs of others, alongside the profound and indisputed needs of the Anishinaabe population. And I'll just end there by saying that, of course, that recognizes that the level of sharing may well look different in the future. The particular percentage of the wealth to be shared in the future may well look different depending on the needs of the Anishinaabe population at the time, the wider needs of other Ontarians at the time, the revenues that are collected. But there's nothing inappropriate about in the assessment for past compensation to consider a share that accounts for the different factors.
You say it's the share result that accounts for the different factors?
I say the share has to account for the different factors. The different factors do come into play in determining a just and honorable share. And it was, in fact, our position throughout the engagement process that primarily factors like the needs of the Anishinaabe population really comes to bear on the decision through this determination of sharing.
Thank you.
And my next point is I want to briefly respond to a point that Ontario made, which was my friend made the submission, and I believe it was, he was speaking in response to submissions from the RHT intervenors and the discussion of Anishinaabe principles. And I heard from my friend that a finding of breach requires an action and a justified infringement analysis. And so this court can't make a finding of breach because to do so would require an action and a justified infringement analysis. And frankly, I'm not quite sure how this submission relates to the proceeding that we are currently engaged in. Because firstly, of course, this proceeding is an action. That is how it started. Ontario has sought to characterize it as a judicial review, but it didn't start as an application for judicial review. And more fundamentally, the breach in this case has already been admitted to by the Crown, including Ontario, and declared by the Supreme Court of Canada. We have a declaration from the Supreme Court of Canada that there has been a breach of the treaty. And so the question that comes before us is the appropriate remedy for that breach, whether the Crown has restored its honor. And I'll point out briefly that, of course, the Crown in this case has never raised or relied on a justified infringement of the treaty in line with the Sparrow decision. So we say that any justified infringement analysis is irrelevant. And so just to end off that point, I say if the Crown has still not diligently implemented the treaty promise and hasn't exercised its discretion to augment the annuities liberally, justly, and honorably in accordance with its relationship with the Anishnabai based on the principles of respect, responsibility, reciprocity, and renewal, then it remains in breach of the treaty. But fundamentally, we have not come to this court asking you for a declaration of breach of treaty. We are seeking an appropriate remedy for the breach that has been admitted and declared. So I should still have time this afternoon to discuss my next topic, which is the human capital rate and the bring forward rate. And we submit that both Canada and Ontario have still failed to adequately respond to our argument that the 60/40 rate is a conservative estimate for the lost opportunity of the Anishinaabe. And that related to the submissions that I made previously regarding how they likely would have spent augmented annuities on human capital, social capital investments. And I would start by noting that my friend for Canada in her submissions last Tuesday claimed that they did address this argument, that Canada did address this argument in its December 20th and January 27th letters, but then added that they were not as clear as we could have been and, quote, do not articulate it well. So I have two responses to my friend's submissions. First is the fact that Canada admits that they did not articulate it well or did not explain it well is itself a problem. One thing that I think we do all agree on is that the Crown bears the burden to explain and justify its exercise of discretion to its treaty partner. Whether you're looking at it through the lens of a reasonableness standard and transparency, intelligence, and justifiability, or whether you're looking at the standard of justification that we say the Supreme Court set out at paragraph 290 of its decision, where it said that the Crown will be required to explain how it reached its determination and why. So again, whether you adopt my friend's submissions on reasonableness standard or whether you simply accept that the Supreme Court set out the standard, we all agree that the Crown has to justify its exercise of discretion. And therefore, it is a problem for the treaty relationship if the First Nations cannot understand how the Crown grappled with its position or a position that they had repeatedly urged upon their treaty partner. And in my submissions, my original submissions, I took you through how this was a position that we had raised repeatedly with the Crown and asked them to take it into account. And so we maintain our submissions that the Crown has failed to meet its standard of justification on this point. And the second point is that Canada does not actually deal with this argument at the parts of the letter that my friend took you to. And so I do want to return to page 28 of Canada's letter, which is page 40 of the revised record.
And you're going to put it up?
Yes, Ms. Angelova will put it up. And this is the section of the January 27th letter that my friend took you to and said, this is where we addressed the argument of the Contingent Interest First Nations about the human capital rate. And we say it's important to look at what Canada actually does here. So they start Canada's reasons for rejecting the 60/40 investment portfolio rate are set out in its written closing submissions and briefly summarized in its December 20th, 2024 letter. And they say the 60/40 investment portfolio approach does not adequately consider risk or depreciation. And it's the next paragraph that I want to focus on. The minister writes in his letter, some of the annuity augmentations that should have been paid would likely have been distributed to individuals and used for spending and investments in infrastructure, business, and human capital. Depreciation occurs in infrastructure, business investments, and human capital. And so this is Canada's explanation in its letter for rejecting the 60/40 approach. And what they say in the letter is, we're not accepting the 60/40 approach because some of the annuities would have been spent on infrastructure, business, and human capital. The First Nations would not have invested it all in stocks and bonds. And of course, we agree that the Anishnabai would have spent their annuities on these sources. Investments and spending in infrastructure, business, and human capital. That's in fact the reason why I provided to you 2 weeks ago why we say actually the 60/40 rate is a conservative, reasonable estimate, because the rates of return on these sources are actually far higher. And the next point in this paragraph is Canada says that that depreciation occurs in infrastructure, business, and human capital. But we say that's not an answer to our argument. Because what we don't see at this section of the letter, even accounting for depreciation, is an argument that the return rate for these types of investments would be less than the 60/40 rate of return. There's no discussion here of accounting for depreciation, what Canada says the rate of return would be for these investments. Is it more than the bond rate? Is it more than the band trust account rate? Is it more than the 60/40 rate? Less than the 60/40 rate? Canada doesn't tell us. So that's why we say that this is not a response or a clear response to the argument that we raised and we asked, or my clients asked their treaty partner, consider this argument. And next, my friend for Canada and her submissions seem to attack or respond to this argument on the basis that, well, Professors Booth and Kersner were the first experts to raise human capital investments, and I believe she characterized it as an afterthought in Professor Stiglitz and Mr. Hutchings' reports. But our position on what the Anishinaabe likely would have done with augmented annuities had they received them, it wasn't based on the reports of the experts. It was based on the testimony of the chiefs and counselors from the communities, who we say know their communities intimately, know the needs and priorities, and who explain to the court the importance of the principle of Mino-Bamadzuen to the collective and how their communities were striving towards it. And I'll repeat again here that this evidence was not challenged either at trial or in the engagement process. And it did happen to be consistent with Professor Stiglitz's testimony on how communities in need would likely have spent additional funds.
Would you say, without giving evidence or anything, some uncontroversial way, would you say that the evidence given by, I don't know who it was, in the engagement process, chiefs and elders, differed in any material way from the evidence heard in stage 3?
On this point, no, it would not. And in fact, there was some discussion in the engagement process. For example, Chief Tangi, during one of the engagement processes, presented a budget of Mishipakatan's needs to the Crown. And that, we would say, was quite consistent with, of course, Chief Tangi was a witness who testified in the stage 3 trial as well. And so it was consistent with, these are the things that our community needs to work towards Mino-Bamadzuen for the collective, or to meet the needs of our community. Things like infrastructure investments and human capital investments. To begin meeting the needs. As this is what we need to start meeting the great and profound needs of our community. So I would say that what the First Nations expressed to the Crown during the engagement process was consistent with, echoed the evidence from the chiefs and counselors at the stage 3 trial.
Thank you.
And right, so what we did was we took the evidence from the chiefs, from the counselors, of how they likely would have spent the annuities, and we combined it with the expert evidence on the rates of return for those types of investments, and particularly Professor Stiglitz's evidence of the far higher rate of return. And that led us to the position of, hey, the 60-40 rate is a reasonable compromise here. So it really doesn't matter which expert raised it first, or was it an afterthought, because it comes from the chiefs who testified in the trial. And my friend for Canada did not address or even mention this evidence from the chiefs in her submissions on this point, nor does it appear in the section of Canada's letter that she took you to and I took you to as well. And we say that that is a serious omission.
You say it wasn't mentioned in submissions, but was it addressed in the January 27th letter?
We say it wasn't, no. The section of the letter that my friend took you to, and I put it back up on the screen, it doesn't discuss the evidence from the chiefs and elders on this point. Or sorry, the chiefs and Councillor Solomon at the time raised similar evidence at the stage 3 trial. And I wish to make a final point here on the model from Professors Booth and Kersner. We hadn't spent much time on it previously because I hadn't understood Canada to be continuing to rely on it substantially, but my friend for Canada did discuss it a fair bit in her submission. So I don't seek to delve into it in detail. I'll just remind the court briefly that what we said, the fundamental flaw of their analysis was that it assumed that First Nations would have spent additional monies, new monies in the form of annuities, in the exact same proportions as they had spent existing funds when they were in great need. Right? It looked at historical patterns of spending and assumed that those patterns would be the same if the communities had an influx of new funds. And even professors Booth and Kersner admitted that there were issues with that assumption in their cross-examination. And if this court does seek to remind itself of the issues that we had taken with the Booth and Kersner model, I would direct your attention to the closing submissions of the group of 7, the written closing submissions from the stage 3 trial at paragraphs 213 to 258, 213 to 258. And so we quite extensively set out what we say are the errors and the issues with that approach. I won't take this court back through them. I just sought to provide you with that reference. So similarly, still on the topic of the bring forward rate, in their submissions, Ontario said that one of the main reasons why they considered the bond rate, and in fact could not consider a higher bring forward rate, is because they considered bring forward rate under factor 3, which is the benefits to the Crown. And as you heard from my friend for Ontario, only the government bond rate measures the Crown benefits. And Ontario submitted that they were simply assessing the present value of Crown revenues, not assessing the present values of annuities that ought to have been paid, or of course, assessing the present value of the losses suffered by the Anishnabai. And my response to this point is that this is an artificial construct by Ontario. There is no reason why the bring forward rate must be or could only be considered under factor number 3. Certainly, the Supreme Court never directed the Crown to consider present value only under factor number 3. And in future augmentation decisions, there may be no need to consider a bring forward rate. Of course, that depends on the frequency of augmentations. But this factor, which of course carries over to future augmentation decisions, may not involve bring forward rate at all in the future. So we submit that the bring forward rate can be considered in relation to factor 1, the nature and severity of the breach, or could be considered in relation to factor 5, because in essence, the consideration must be what is necessary to compensate the First Nations for the breach. And it's really not a sufficient answer for Ontario to say, well, we decided that we were only going to consider the bring forward rate under factor number 3, therefore we don't have to consider your losses. And finally, I'd point out that this is inconsistent with Ontario telling you that, well, the minister took a holistic approach to everything, and the minister considered all of the factors holistically. Yet when it comes to bring forward rate, they say, well, no, you can only consider that under factor number 3. And we say that that's inconsistent. So I only have one more point. I think it should take about 5 minutes or so before then we move on to Mr. Gover's submission. So perhaps I propose that I finish my point and then we start with Mr. Gover first thing tomorrow morning.
Please go ahead.
So my last point is on reconciliatory justice. And Ontario said that reconciliatory justice is not always corrective justice plus something more. And we say that that is a straw man argument because we agree that in certain cases, reconciliatory justice may look very different than what corrective justice looks like. But we're dealing with this case. And in this case, reconciliatory justice requires at least that the Crown compensate for the harms that they've caused to the Anishnabai people through their breach of the treaty. And these are harms that arise in large part, but not necessarily exclusively, from the wrongful withholding of annuities that the First Nations were entitled to. And so it makes sense that the remedy will, in large measure, be a monetary remedy. And again, it's helpful on this point to go back
Would you
to, sorry.
Just ask this, would you say that that's hard for me to ask this question to you, but would you say that the Crowns would agree with that characterization of what happened? Wrongful withholding of? Or is the more neutral characterization not considering?
I will say that the Crown did agree with that characterization before the Supreme Court of Canada.
Okay.
And yes, the Supreme Court did say that the treaty, the augmentation promise was a promise to exercise discretion to consider annuity increases. But before the Supreme Court of Canada, both Canada and Ontario said, we admit that there have been great revenues from the territories over the past 175 years, and that the annuities should have been augmented. And that's the breach. And I believe the best reference for that is perhaps paragraph 150 of the Supreme Court decision.
Thank you.
And that's where the Justice Jamal is discussing, well, there may not be a big difference between interpretation number 3 and interpretation number 4, given that the Crown has come to this court and said the annuity should have been augmented.
Thank you.
So on this point, I think it is helpful to return briefly to the Takuhikan decision, which was of course, the first case on reconciliatory justice, or at least using that term as such. And I spoke briefly when we were having a discussion, Your Honor, about that case involved the First Nations suing the Crown, Quebec and Canada for the refusal to negotiate the funding of their police force honorably and in good faith, which resulted in them taking on these large deficits to ensure that their police force could continue to function. And so we need to look at what did the majority of the court determine was the appropriate remedy in that case, consistent with reconciliatory justice. And it was ordering the Crown to pay the full amount of the deficits. Essentially, they said that the honorable remedy, in accordance with reconciliatory justice, is to compensate the First Nation for its past losses. And corrective justice in that case would have required a damages assessment to account for and deduct the amounts that Quebec had provided in additional funding over the years. So rather than take the full amount of the deficits, do a damages assessment, a trial to determine, well, how much did Quebec actually provide in funding through other sources over the years? And the Supreme Court said, well, when we're talking about reconciliatory justice, that's not necessary. In the interests of a flexible remedy that looks both towards the past and to the future relationship between the parties, we're ordering the Crown to pay the full amount of the deficits.
But can you say that that is directly applicable when we're talking about, I think the number I had last week was 1.2 million was the amount, Or was it something different than that?
The amount of the deficits in Takuhikan, I think it was around that.
Okay, 1.2 million. And can you say when the Supreme Court says, look, we're just going to order the full amount of the losses, and that's the amount they're talking about, do you say when we have, I don't know how many more zeros than that, that is an applicable reasoning that you can bring to this court?
Yes, we do. And what the Supreme Court said, or Justice Kazira writing for the majority of the court said, is that we do have to consider proportionality here. And admittedly, the fact that it was a relatively modest amount that the First Nation was seeking, the court said, well, it's not in keeping with reconciliation to make the parties go back to a potentially long, expensive damages trial to sort this out.
Right.
And of course, the amount that we are seeking here is significantly larger than the amount in Takuhikan. We don't deny that, but that principle of proportionality still comes into play. The damages in Takuhikan, or the process in Takuhikan, I believe, took around a decade. What we're dealing with now is breaches for 175 years up to this point. And so we say in the context of the long-standing and egregious breach that we have in this case, much longer, much more egregious than what the court was dealing with in Takuhikan, well, then in that case, proportionality also, we say would not require sending the parties back to a further engagement process, to further discussion.
But that's on the point of which remedy, not on the point of this notion, which is what I was asking about, of just saying, okay, we hear that 100% of the losses was 1.2, we're just going to order 1.2. And the court used a proportionality analysis and among other things, to come to that conclusion. And you say that is the proportionality analysis is a good answer to sending it back versus having the court determine. But I was asking the question with respect to this notion of ordering full coverage.
Right. So the first point I'll make, and my friend has helpfully pointed out for me, that the amount claimed in Takuhikan was about $762,000.
Yes.
So significant. I thank my friend for that. But
Your Honor, I think that might have been from Quebec only, and with Canada it was 1.5 altogether. Sorry, that was Canada only number.
The only issue is what.
Okay. I don't think much turns on the amount, whether it's around 750,000.
I promise not to say.
It's I think we all admit that the amount being claimed here is significantly more. So I don't think any turns on the precise amount there. But to the point, what Takuhikan does teach us is that reconciliatory justice must be flexible, and that the court can be creative, and that where there is difficulty assessing the precise amount of the loss flowing from the Crown's dishonorable conduct and not arising in any way from the conduct of the First Nations shouldn't be penalized for that. And so that is why we've said, taking those principles from Takuhikan, we know that the assessment here must be a flexible assessment. And it doesn't have to be a precise mathematical calculation of all the losses that the Anishnabai have suffered. And so to throw into that mix the flexibility, the proportionality, this court can also consider, and the Crown ought to have considered as well in the engagement process, that the First Nations had made significant compromises on a number of points. And said, we're not going to insist on, the maximal positions. And the point as well, where I started this off, is that reconciliatory justice in the Takuhikan case did require more than corrective justice. And that was in the name of repairing the relationship going forward. And so if you told the average person that reconciliatory justice meant providing less compensation than what might otherwise be available for wrongful conduct, I'd submit that they would be quite shocked. And simply framing reconciliatory justice as something different than corrective justice should not justify offering less compensation to the superior Anishnabai in this case. And this framing dilutes the Crown's duty to repair the harms of a long-standing constitutional breach and reframes reconciliation as merely a forward-looking gesture of goodwill. And we say that is a distortion of reconciliatory justice. And reconciliation cannot mean doing less in the face of greater historical harm on a nation-to-nation basis. And I appreciate the court's indulgence in going slightly later. Those are, barring any further questions, those are my submissions on behalf of the Contingent Interest First Nations. And so Mr. Gover will be prepared to make his submissions for our side first thing tomorrow morning.
Thank you. I just have one thing I'm going to ask you to do, please. I'm just trying to figure out the paragraph in the Supreme Court decision, which I would like you to point me to.
Okay.
And it's where the court says to have a damages trial would be to deprive the First Nations of an opportunity to renew the relationship. I have a question with respect to that paragraph. Could you just tell me what
I believe 300.
Thank you.
Just double checking.
Second last sentence.
Yeah, right at the bottom of the paragraph.
I believe it's paragraph 300.
Okay.
Please let me know if that's not the paragraph Your Honor was thinking of.
Yes, this is it. Thank you. So tomorrow, whoever is up, please. The question I have is whether this goal of the court, which I would characterize this comment as a goal of the court with respect to the engagement process, this opportunity to where is it? It starts with, given that the central goal of the treaty was to renew the relationship, and without an engagement process, the superior plaintiffs would be deprived of the relational aspect of the treaty if this litigation were to proceed as currently conceived. So I take those two parts as some expression of a goal, the court's goal in ordering an engagement process. And my question that I would like someone from the plaintiff's side to address is, did the engagement process meet that goal?
I think I can answer that quite I can answer that now, and the answer would be no.
And do you say that in any of the material that's going back and forth between the parties during the process? Like other than, I get your opinion, but is there an expression of those goals and those, whether they're being fulfilled or not?
There is and you'll see it in the letters that we sent, and you'll see it in the minutes from the engagement sessions, that the First Nations and especially the chiefs and the counselor who are at the meetings expressed repeatedly that their frustration with the process that they were engaged in, because it was not meeting that goal of a nation to nation engagement of equals that was the foundation of the treaty promise, that treaty relationship. And they said, you are not engaging with us as you are required to under the treaty. You are simply giving us an opportunity to blow off steam, or you're simply listening to us, telling us that you're going to listen to us, and then you need to go back and take a position on what we said.
Okay.
And so we would submit that that is not the relational aspect of the treaty that the Supreme Court was envisioning when they made those comments at paragraph 300. And of course, those statements.
I'm going to take your answer as an answer from the perspective of the First Nation parties.
Certainly from the perspective of my clients. I'm not sure that Mr. Schachter would disagree, but I'll allow him to speak for himself when he's on his feet.
Things start to happen very quickly after 4:30. Okay. All right. Thank you.
Thank you.
All right. And that's it for the day then?
It is, yes.
Thank you very much. On your advice, we will return tomorrow at 10.
Court is adjourned until tomorrow at 10 a.m.